Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Chartier Nyamfukudza from Chartier Nyamfukudza, PLC. Now let's discuss some remarkable stories and real cases.
On today's episode of In the Name of the Law, we're going to be talking about litigation against schools and universities under Title IX, a compelling criminal case, and protecting your family by using powers of attorney.
In the name of criminal defense.
I have with me Mary Chartier and Chartier Nyamfukudza, criminal defense attorneys. There have been at least 281 mass shootings in the United States in 2022, according to the Gun Violence Archive. As of June 8th of this year, there have been 27 shootings at schools, according to Education Week, which has been tracking school shootings since 2018. President Biden recently signed into law the first major gun legislation passed by Congress in nearly 30 years. Mary and Chartier are going to tell us about this new law and what it does. Chartier, what does the legislation do?
Thank you, Liisa. The Bipartisan Safer Communities Act gun safety bill includes incentives for states to pass so-called red flag laws that allow groups to petition a court to remove weapons from people deemed a threat either to themselves or others. Also, it expands an existing law that prevents people who are convicted of domestic abuse from owning a gun to include dating partners rather than just spouses and former spouses. This was called the boyfriend loophole in the past. And finally, the bill expands background checks on people between the ages of 18 and 21 seeking to buy a firearm.
So is the bill focused entirely on prevention of gun violence?
So it also focused on, there was a group of gun sellers, and now they can be registered, they have to be regulated. I mean, the regulation is pretty minimal. But for individuals who sell firearms and it's their primary source of income, there was a little bit of a loophole or a gap in that. And then there also is funding for mental health, not nearly enough, I think, but this was certainly a good compromise when nothing had been done. And we know that mental health is a really significant portion for a lot of gun violence that we see. I mean, when you look at things like Uvalde, so many of these mass shootings, which are just heartbreaking, frequently the individual doing the shooting, not the individual in Highland Park, but a lot of these shooters are not just homicidal, but they're suicidal as well. And so if you address that portion, you could ideally save other people's lives, innocent people, and the lives of the shooter as well, because we wouldn't even get to that part where someone is going into a school and shooting up young school children and teachers.
Right, and if I may add, problem-solving courts, certainly like the mental health courts, but drug courts and veterans courts, which, near and dear to my heart. I've been a mentor in our Ingham County Veterans Treatment Court for a long time now. But those will also benefit from the nearly $750 million that's been earmarked for crisis intervention programs.
So who opposes the bill? Or the new law?
Well, no surprise, the NRA, right? I mean, the NRA opposes the bill. The NRA opposes essentially any sort of restriction or regulation on Second Amendment rights. And what's interesting, I mean, just so you know, is, your two guests today are gun owners, right? Chartier was in the Army for 12 years. He owns guns. I own guns. Chartier, am I a great shot or what? Right? I'm a very good shot. I really am. Right. I mean, I'm like really close to that bullseye, like pretty much all the time. But so every right that we have under the Constitution has some restrictions and some regulations. If we think about even just the First Amendment, I can't defame someone. If I do, I can be sued civilly. So if I were to say, Chartier just punched me in the nose, he could sue me, which is not true, but he could sue me for defamation. If I were to threaten somebody, I'm going to come over and punch you in the nose, Chartier, he could have me criminally prosecuted for that threat. And everybody knows, I know, and I take boxing classes, right? So I'd be pretty good at that. But everyone knows you can't yell fire in a crowded theater, right? So there are restrictions on every single constitutional right that we have. And we just learned from the United States Supreme Court that as women, we have no constitutional right to control what happens to our body once we become pregnant. So, and some people are looking, according to Justice Thomas, at wanting to allow states to prohibit contraception. So it's just remarkable. But the NRA opposes any sort of restriction on the Second Amendment, which really defies logic when you look at other restrictions on other amendments. So the NRA opposes it as they oppose any sort of regulation or restriction. Nobody wants to, well, I don't want to say nobody, there's probably extremists on either side, but no reasonable person and no reasonable politician wants to take guns out of lawful community members' hands. It's just a matter of stopping people from getting shot when they go to the grocery store. Little kids go to school. I mean, the last day of school is literally the last day of their lives. How on earth can someone justify assault weapons in the hands of an 18-year-old? That person cannot even legally drink, right? They cannot even go and have a beer. They cannot even go legally and smoke a marijuana joint in most states, yet they can go and possess an assault rifle and take the lives of so many children.
Was this law a bipartisan effort, and did the sponsor of the bill achieve what he wanted to achieve, or she?
So Senator Chris Murphy, Democrat out of Connecticut, who led the negotiations between the 10 Senate Democrats and Republicans, called the bill a compromise, right? It doesn't do everything that he wanted, but he believes it will save thousands of lives without violating anyone's Second Amendment rights. And again, already we've lost in churches, parades, too many places to name. It's actually difficult to keep up.
Right.
Grocery stores, subways. It's actually difficult to keep up with all the shootings. Here in Grand Rapids, there's a couple on their wedding day. The husband got shot, I think 10 times. Thankfully, he survived, but someone else lost his life. So it happens everywhere, all over the country.
Well, what was the last significant gun legislation that we had in the United States?
Well, that was in 1994, and that prohibited the sale of to civilians, weapons like the ones that were used at Uvalde, but it expired 10 years after that. So it's 2008. It's been 18 years since that expired. I had to do a bit of math.
So the Supreme Court recently made headlines for a gun-related decision. Mary, can you tell us a bit about that case?
Sure. So it's really an extremely significant decision. And, for viewers, our Supreme Court composition has changed. And so New York had a concealed pistol or concealed weapons law that essentially said in order to be able to get a license to carry a concealed weapon, you had to show good cause for the reason that you wanted the concealed weapon. The Supreme Court said, no, that's essentially making the Second Amendment a lesser amendment. So you don't have to show good cause in order to be able to possess a concealed weapon in New York. There are a lot of states, or a fair number of them, that have that law. They're all going to be going away. Now, what was interesting is the justices said this doesn't stop states from requiring background checks and waiting periods and those sorts of things. I mean, we'll see, right? Because a lot of these justices were the same ones when they were sworn in who said Roe was settled in this country, and we know that Roe is not settled. Now that leaves it up to states. What's really interesting, though, is this dynamic, and I don't think it's going to be settled by legislation, and I don't think it's going to be settled by the courts. I mean, we really, as a society, have to start looking at why are we so obsessed with guns, and not that people can't possess them, but why do we think that possessing a gun and shooting it at a person is some show of strength? I mean, I don't think there's a weaker individual who goes into a school and shoots unarmed little kids. You know what I mean? And teachers who are really just there to teach them math and, English and how to be, good little community members. That's not a show of strength. That's that's a show of weakness. And until we as a society really start looking at culturally how we address these issues, no gun legislation, no gun reform is really going to address the underlying issue.
Right. Well, thank you both for sharing your time with us today.
Thank you, Liisa.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC. in the name of family law.
We're here to talk about using a power of attorney to protect your family. I'm with Kent Wood, who's an attorney and owner of Wood & Associates with offices in Lansing, Battle Creek, and Grand Rapids. Welcome, Kent.
Yeah, thanks.
So
Nice
tell
to
us
hear.
about the different types of powers of attorney.
Well, the two main types of powers of attorney that we run into when we're dealing with families is a medical power of attorney and a financial power of attorney. Now, medical power of attorney is this document that you pick somebody that can make decisions for you, for medical decisions and care decisions, when you can't. And it's a springing power of attorney. This is this concept where you have it, it's there, it's available, but it's you, as long as you can communicate in any way. I often say if you can blink your eyes or tap on paper or nod in some way, as long as you communicate what you want in any way, then you get to make the decision. Medical power of attorney only comes into play when you cannot make a decision. The issue we run into with families is when they don't have them is the loved one's going to the hospital, there's a major decision to have to be made, they're either illness or accident can't communicate, and surgery may be needed or other kind of treatment might be needed. The hospital is going to make the most self-protective decision possible for themselves. They have to pay insurance and other things and malpractice issues, so they're going to do all the life-saving measures. They're not going to consider quality of life. They're not going to consider the interaction with people, just whether or not they're going to be in a vegetative state or what part of the bodies work or don't work at all. Whereas with a medical power of attorney, you can have somebody chosen to make the decision. Someone can do the ultimate decision where they talk about pulling the plug, or the other decisions where if they're going to be brain dead or they're going to be vegetative state. Or I've told my children, for example, if I can't use my arms, let me go. If I can be okay without my legs, but with my, I just know that about myself, so I have to have that discussion. And so my power of attorney have that kind of language in them. They can be as specific as you want or as general as you want, but they allow you to do other things too outside of just that. Somebody has a capacity issue, mental health care, and they lose from dementia or Alzheimer's, no longer make decisions, and they need long-term care. Well, you can get them into a facility. You can get them out of a facility. You have the power to hire and fire doctors, hire and fire nurses. If you don't like the way your loved one's being treated, you can stop that. And this would give you the power to do just that.
And so you said the medical power of attorney is springing. So that means if the person is incapacitated, unconscious or whatever, maybe they just had a car accident, that just temporarily goes into place. And if they come to or are able to communicate, that goes away?
Yes. Yeah, it doesn't go away in the sense that there's still a power of attorney. It's just now, as long as you can communicate, you make the decision. Okay. So if there's a period of time where you can't, a period of time where you can again.
And so hospitals know the difference? They know how that works, I take it?
Yes.
Okay.
And if they don't, the power of attorneys that we draft have provisions in it to where it gives the power, your patient advocate the authority to go to court and make sure they know. If they don't
Is a patient advocate somebody who's identified in the power of attorney?
Yes. So we call the power of attorney for a medical power of attorney patient advocate. Okay. When we deal with financial powers of attorney, we call them the durable power of attorney.
Okay.
Financial power of attorneys are important too because they give somebody access to your bank records, your bank accounts, your investments. They can do anything you can do with money. That's how they're drafted. But they're not springing. They can't be springing in Michigan. They have to be effective immediately. So once it's signed and in place, that person can walk out and go to the bank and get a loan in your name. So you don't give them away. We'll tell people to leave medical power of attorneys with every doctor they see and every specialist they see.
Right.
Make sure it's in your file.
Okay.
Whereas the financial one, you just keep it at home and tell the person where it is when they need it.
Yeah.
Now, they can't do more than what they're allowed to do. So even though it says they could go get a car loan, they still need your permission to get the car loan. But there's no way the bank's going to know without checking on you, or the car dealership, depending on where they go. But so they're still liable for only being able to do what you want to do, but they're effective immediately.
So when would a person want to have a financial durable power of attorney in place?
Well, before they lose capacity is always a big one. If you have, I think we talked about mental health a moment ago, but again, mental health issue where someone has Alzheimer's, dementia, they can't manage their own finances anymore. Once they reach that point, you can't sign a power of attorney. It's like a contract. You can't sign it. So you want them in place before that happens. So if your family has a history of that, you should consider doing it sooner. I always kind of say, hey, between 55 and 60 is a good time to make sure you have these if you don't already. If you're a single person, right? A lot of hospitals and people will give deference to spouses. Spouses are normally on bank accounts, so they have access anyway. But if you're a single person, you definitely want to do that. Or if one of your parents have passed away, that'd be a good time to make sure your survivor has that in place.
I think I have a financial power of attorney that I've already signed because it makes my husband my whatever. Like, does that make sense that we would both be on each other's right now while,
Well, yeah, you can be joint owners or joint account holders or signatories on various products.
Yeah.
That just says they're allowed to access it just like they were me.
Right.
They're allowed to use this credit card. They're allowed to use this bank account. So you don't need a financial power of attorney when those things are in place. It's when that person's no longer there.
Okay.
Or one of the two people are no longer there. It's when you're going to need it. So you want to make sure you have it.
So because they go into effect right away, should people be having them prepared, drafted, ready to go? So all it needs is a signature when it's go time?
Well, you should have it signed once it's drafted.
Okay.
Right? Because if you don't sign it, say we draft it, we don't sign it when it's done, and a few years later, your mom or dad has Alzheimer's and can no longer have capacity. If they haven't signed it, it doesn't matter at that point. So you have to have capacity at the time of signing.
Okay.
Other thing with financial power of attorneys, I don't take all the time here, is they can be limited too. They can say, I can have a financial power of attorney, go buy me this car, go buy me this house. You can do this or that. Don't take loans.
Don't people do that a lot? Like if they're, just say they're out of state for some reason, or maybe deployed in the military, or they need somebody back home who's going to take care of business while they're gone?
Oh yeah, definitely. Right? And definitely with people with children, we do a temporary, basically power of attorney where you can make decisions for your child while you're gone for 2 weeks on that fun vacation, the spouses.
Right. Okay.
So there's lots of ways you can use those power of attorney, but those two are the big ones for the long-term care for people.
So it's not just for like the adults trying to manage their finances, but like if you leave your kids behind, you can have something in place that's going to take effect while you're gone.
Yep. Also, another way medical power of attorney is beneficial is if you've got a kid going off to college, you might want to have a medical power of attorney so that if something happens and you call the hospital because your kid's at the hospital across the country.
And you're over 18 years old, right? So you no longer have
You don't have
power,
any access, and they will not give you the information without authority.
Okay, that's a great tip, Kent. Get a power of attorney for kids going off to college. Okay. All right. Great. Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
The federal law known as Title IX has helped bring equality and reduce discrimination in public schools and universities. The law has also provided important rights to people who have been victims of sexual assault in public schools and university settings. Now, this summer marks the 50th anniversary of the passage of Title IX. However, rather than just celebrating the law, we have Steve Sinas from the Sinas Dramis law firm with his colleague John Homa to discuss a concerning United States Supreme Court decision impacting Title IX rights of sexual assault survivors. Steve and John, it's good to have you here.
Thanks for having us. Good to be here. Thank you.
Steve, what does Title IX provide? What kind of rights to people who have been sexually assaulted in the public school and university setting?
Well, as you already touched on, I want to acknowledge that Title IX has done a whole lot of good for this country, especially to bring equality and reduce discrimination in public schools and universities. It's especially helped females in the athletics. And so it's done a whole lot of good. It's also provided important rights to people who are sexually assaulted in a public school or university setting where they can show that the school or university failed to take the steps necessary to protect them from that type of an assault. And in those situations, Title IX has provided them the right to pursue a civil claim where they can recover what are known as economic damages to cover their medical expenses, and also to recover their non-economic damages, which is compensation for their pain, suffering, and mental anguish that arises from the sexual assault. Now, I want to say that there are other ways people who are victims of sexual assault in the school setting can pursue civil justice, but Title IX has been an important one and has definitely recognized those two types of damages, economic and non-economic damages, as being recoverable. But John's going to explain to us how the Supreme Court may draw into question whether those damages still are recoverable.
Okay, John, so what case was it at the United States Supreme Court, and what was that decision all about?
Sure. Well, the case is titled Jane Cummings versus Premier Rehab Keller. And this case, I'll just make the point, involved two federal anti-discrimination statutes, the Rehabilitation Act and the Affordable Care Act. It didn't address the Title IX law specifically, even though it was discussed at length in the opinion. But it's important to recognize that the two statutes that were addressed in the Cummings case are enacted by Congress under the spending clause to prevent discrimination in certain institutions, very similar to what Title IX does in the educational setting. And in Cummings, it involved an individual lady, Jane Cummings, who was deaf and requested a sign language interpreter for her rehab therapy, and that was denied. And so she ultimately ended up bringing a claim under the Rehabilitation Act and the Affordable Care Act to seek redress for the discrimination she experienced in this Medicaid state environment. The court ultimately held that in a case involving these discrimination statutes, that her ability to receive compensation was limited, specifically that she could not receive compensation for any emotional harms or any emotional losses that she suffered as a result of the discrimination.
So how did the court reach that holding, and how does it impact Title IX cases?
Well, the court reached the holding by analyzing the statutes that were at issue, and they recognized that these anti-discrimination statutes were set up under the spending clause, and they apply to federal funding recipients and essentially form an implied contract between the funding recipient and the government. And in order to receive the funds, the funding recipient agrees not to have discriminatory practices within their environment. And so the way the court reached its holding is it recognized that traditionally, under a breach of contract theory in our common law, emotional damages are not recoverable. And so the court applied that same analysis to these cases and says, because they involve a breach of an implied contract between the funding recipient and the government, that the only damages that someone can really recover for a breach in one of these types of environments is limited to economic damages only, and they cannot receive compensation for non-economic damages or emotional suffering, because it just simply wasn't recognized as a form of damages that are recoverable under contracts under our common law.
And that's how it ties into the Title IX issue?
Yeah, well, with the Title IX, it's the same type of statute. So
Okay.
the concern at this point is that this decision is now going to be interpreted to apply in the same way in Title IX, so that people bringing
Got it.
claim under Title IX for compensation for sexual assault are going to be faced with an argument that the non-economic damages they're pursuing may not be recoverable.
And
Okay, thank you. Now I understand. So if Title IX may not provide these people with compensation for their pain and suffering and their emotional harm damages, are there other claims that these sexual assault survivors can bring to recover those types of damages?
Yeah, and the first thing to understand is that if you're a victim of sexual assault, you have rights to have the person criminally prosecuted and the state brings those charges. But if you want to bring your own civil claims for compensation for what we've been referring to as economic damages or your non-economic damages, you may have various types of claims that you could bring depending on the situation. So every sexual assault claim is unique and needs to be analyzed based on its facts. And in the public school setting, that's definitely the case. And that's where Title IX applies, that the public school or university setting. And even if this decision were to be interpreted in the way that people fear it may be, these people can still pursue other claims under federal laws known as Section 1983 for for a violation of their equal protection rights, their deprivation of their fundamental rights for their bodily integrity. And there's also state law claims that they can bring. So it can get pretty complicated in these types of cases, but it's not that these people don't have any ability to recover non-economic damages. It's just that unfortunately our United States Supreme Court has made it more difficult for them to make those claims.
So to help me understand, if a sexual assault survivor is bringing a Title IX claim, they're suing the university or their school, are they also in the same case suing, like, for example, the assailant or employees of the school, like maybe who allowed it to happen? Or is it just against the university itself?
Sure. Well, I'll tell you, there's various state claims and federal claims that are brought in these types of cases, and it's quite typical that several school officials and other entities would be named in connection. The Title IX claim is specifically geared toward the federal institute or the institution that receives the federal funds, so the school itself. And it's particularly important because quite often public schools and universities have some level of governmental immunity in function of their jobs. And Title IX was really the framework that we've used over the past decades to help hold schools liable for their own acts of harm in connection with sexual assaults. But certainly there are very other entities and individuals that could be named alongside the institution itself.
So if we're holding the institution responsible for these things that are happening there, doesn't that encourage them to be more proactive to prevent bad things from happening at school too?
Yeah, and a big part of Title IX is that they have rules that apply to how they have to investigate sexual assault, have to respond to it. And so it's certainly still helping people have protection in schools. It's just that these claims arise against the school system when you can show that they failed to protect them in such a way. And that's where the liability comes from under Title IX.
And I'll make one more point here. The damages and the emotional damages that have attached through the cases in the past decades really brought teeth to the law. I'm not aware of one situation where a school has had their federal funding minimized or taken away because of their discrimination. So this form of relief was really what gave Title IX its teeth and helped prevent sexual assault from happening in the schools because it was a strong deterrent for the institutions.
Got it. Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for watching In the Name of the Law. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.